Today we're going to talk about technology transfer and IP contracts in China. This is the table of contents. We will start with a brief introduction to all the intellectual property rights, an introduction to what technology transfer is, what are the main rules in China for technology transfers. We will talk about a little bit about bureaucracy. And finally, I will give you some tips that will help SMEs how to transfer technology in a more safe way, how to study your business partner, how to protect your trade secrets, what are the different company types, and what are the main clauses that contracts should have. But let's start with the introduction. When we're talking about intellectual property rights, we are talking about a different variety of rights. We have innovation patents and utility models which protect the inventions, those aspects of technology that are technical, that are innovative. They protect not only final products, but they also protect how to produce different processes of production. The difference between innovation patents and utility models is very simple. Utility models are just a simple IP right that has the same requirements as innovation patents. The difference is that when the intellectual property agency is analyzing those requirements, in utility models, it's less strict. Those requirements are novelty, non-obviousness, and industrial application. When we are talking about design patents, we are talking about the aesthetic aspects of a product. It also requires novelty, and this novelty should be global. It should be worldwide. Once your company discloses the design of one of your products and you haven't registered yet, then in the case of China, that the patent design will be rejected. The protection is lost. That's a significant difference with Europe, because in Europe there are certain ways of protection for design patents, even if they were disclosed. In the case of trademarks, by trademark, we understand any sign that helps to identify your products and services in a market. So it could be almost anything that helps your product to be distinguishable. For example, it could be the name, it could be a logo, but also it could be a sound, smell, whatever. It could be also a combination of those elements. When we are talking about copyright, we are talking about the expression of an idea. Copyright do not protect the idea itself. It protects how this idea was expressed by an artist. It requires originality. This means that it hasn't been copied from a different piece of art. In the case of companies, copyright has a very specific usage. It protects software. In China, software patentability is highly discussed. It can be protected, but only in certain specific moments. There are very specific requirements, so the vast majority of software will not be protected by patent, but yes, by copyright. So this is the main usage for companies. Trade secrets, and this is very important in the case of technology transfer, also in combination with know-how, because both trade secret and know-how, they cannot be registered by definition, by how these intellectual property rights are planned. They cannot be registered. So companies will be unprotected if one of these knowledges, because at the end of the day these are knowledges, get lost. In the case of innovation patents, design patents, trademark, and copyright, because there is a registration system, it is possible to protect it in advance before starting. It could be before negotiating, or at least before signing the contract. But in the case of trade secret and know-how, that will not be possible. What is a trade secret? It's Any knowledge, any information that has value, this means that has commercial value, companies will pay for it. That is a secret, this means that it's not known by several of the competitors, of the members of a certain market. It can be known by more than one, but it shouldn't be known by the majority, or at least a significant number of players. And also that is protected by protective measures. This could be physical, this could be electronic, but we will talk about this later. Regarding know-how is a practical knowledge on how to accomplish something. This means that is the expertise that could be your own or your employees have about the technology that you will be transferring. A patent itself, it may not contain all the necessary information for having a proper usage of the technology. For example, if you are talking about an innovation patent about a process of manufacturing certain products, even though the patent was registered, when taking this patent into reality, there is some knowledge that is always lost, and it's known by those people who actually have the technology in mind and know how to use it and know the potential problems. And this know-how, it's also one intellectual property right, and it should be protected by the techniques of trade secrets. Finally, there are two main principles about intellectual property rights that are significantly important, especially in China. The first one is the registration principle. This means that those intellectual property rights that are based on registration, this means innovation patents, utility models, design patents, trademark, and copyright, will not have any kind of protection in China if there is no registrations. This means that if you haven't registered your design patent, your trademark, or one of these intellectual property rights in China, then you will not have protection in China. This is combined with the territoriality principle. This means that the registration done will only have effect within the territory of the country that you register with. This means that your registration done in China will only grant you protection in China. Or in other words, any registration done by one EU company, but if the registration was done in the EU, then you will have no protection in China. We also have to take into consideration that in the case of China, we have several jurisdictions. We have mainland China, Hong Kong, Macau, and Taiwan. So these four jurisdictions has their own intellectual property office and will require a different and independent registration. So when we're talking about technology transfer, what are we talking about? What's the meaning of technology transfer? It's the movement or flow of technological knowledge, data, designs, prototypes, materials, inventions, software, and even trade secrets. What are we transferring exactly? What we are transferring are intellectual property rights and knowledge in general. Remember, when we are transferring intellectual property rights, we are transferring the registered ones, but also the unregistered ones. So there are different ways of how technology can be transferred. It not only could be transferred by contract, because sometimes this technology transfer can be unconscious and sometimes unwilling. So when a company is a consulting company, for example, they are transferring know-how, maybe they are transferring trade secrets. When you have graduating students, there is a technology transfer from the university to the society or to a company. When there is a collaborative research, we have a situation of of both parties that adding knowledge to a common goal. It could involve, most likely will involve registered intellectual property rights. When we are patenting, this means when we are registering a patent, we are also transferring technology. Because when we are patenting in the patent process, registration process, there is one moment in which the patent will be published. So in some way, we are transferring the technology we are making available for third parties. Of course, thanks to the patent, we will have a protection after the registration is, the patent is granted. However, remember the territoriality principle. We will have protection only within the territory of the country where we are registering, but we will not have protection in the other countries. But the patent will be available because it will be published, and it will be publishing for everyone who is capable of analyzing patents. So the technology will be available in those territories that are not protected. When we are patenting, we are transferring technology. When we provide service and outreach, it's also one method of technology transfer. I forgot to mention before that when we are licensing technology, this is the most common, and I think the example that everyone has in mind when talking about technology transfer. A license is a contract in which one party transfers technology to a second party in exchange of, it could be money, another technology. This is cross-transfer technologies. And this is the most, I think, common example. The other one is when we are creating a joint venture or a spin-off company. This means that one company creates a second one, giving to this second one some technologies in order to have a separate goal. For example, it's very common that a company develops a product that can be independently exploitable. So they just created separate companies just for taking care of that business part. What are the rules for technology transfer in China? What are the most relevant laws? The most significant one, I think, is the foreign investment law that came into effect this year. Sadly, we still do not have many cases because of the situations that is known by everyone that has difficult performing businesses in the last almost entire year. So we still haven't seen many cases about how this law how this law works in practice. However, we expect to see it in the next year. What are the most significant rules that this law brought? The first one is the national treatment. This means that foreign investors should be treated or will be treated in the same conditions as nationals. The law says that these investors will be treated in the entrance level of the technology transfer or on the investment. This means that those foreigners will be treated as national when applying, for example, for permissions, for licenses, when having access to funds, land supply, tax exceptions. However, it could be the situation that for certain specific technologies that are encouraged to be transferred into China, they can receive even some preferential treatments. But we will talk about this a little bit more in the next slide. The second rule that establishes the investment protections. This means that we'll provide foreign investors to have a free capacity to remit profits out of China. By profits, I mean not only the profit from the business, but also the capital gains, the income for asset disposals, royalties from intellectual property rights, and compensations that they receive. There will be no restrictions on currency. And this rule also applies that there is a prohibition to require to a foreign company to be forced to transfer technology. So this was one of the main concerns for EU companies if they will be forced to transfer technology. But according to this law, it will not be, no company should be required to that. So if that situation happens, there is the possibility of complaining. Investment administration, this rule is combined with a different rules that we will talk about later. Is the regulation on the administration for import and export technology. There are certain areas of investment that can be restricted and even forbidden, but with the next rule we will see it with more details. Also establish legal liabilities to those companies that fail to comply with the limits imposed, particularly with the company types. We will face legal liabilities. Finally, this law also established modifications to the company types. Before there were 3 types of technologies that they were reduced into only 2. That is the whole foreign-owned enterprise that remains almost exactly, and the joint ventures. That is actually a combination of the 2 different types of joint ventures that were in the previous law. But when we were talking about the import and export technologies, the tiers, we're actually talking about these catalogs that you can see on the slides that are very, very important when taking into consideration and when planning to transfer technology to China. You have the catalog for prohibited and restricted technology imports, and exactly the same, the catalog for prohibited and restricted technology exports. This means that these 2 catalogs, they define what technologies can be export or import into China and from China. You have to take into consideration that these catalogs do not have the same content. So your company may be able to import one technology to China, but it would be restricted or even prohibited to export this technology out of China. So why is this important? Because if your company is planning to transfer a technology into China, this means to import the technology. In order to develop it, get a better version, an improved version of the same technology, and then export it out of China to could be your headquarters in Europe. Well, if this technology is able to be imported but unable to be exported, then you won't be able. So when taking into consideration, when analyzing the usage of the technology, you have to take in mind both catalogs. When we are talking about restricted and prohibited, what we are talking about? Well, technology can be classified into freely importable, that there is no limit at all. Restricted, this means that your company will have to request permission in order to import or export the technology. And prohibited is that even though if you request for permission, you won't be able to get it. What's the procedure for obtaining a permission? In the case of importing, the Chinese party, this means the Chinese company that will receive the technology, we have to request to the competent foreign trade department of the State Council. It's a request, an application that they have to submit. It takes 30 working days. And this request should be done before even signing the contract. Because if the permission is granted, it's actually a permission for signing that contract. that after it's being signed, it should be submitted again for a final approval, that it takes around 10 working days. In this case of export technology, it's a very similar procedure. This means you have to request for a permission, then sign the contract, and then submit the contract. But in this case, if you are exporting, you already have some company or the company that is in China, that is the owner of the technology, is the one that has to apply. But also we have to take into consideration that in China we have the negative list for foreign investment. That is another catalog of technologies or areas that foreign investors can or cannot invest in. Also, this content may not be the same one with the import and export catalog. So when investing in certain technologies in China, please take into consideration. Because in this case, this means that there are three ways of foreign investment. The first one is the free to invest. This means that foreign investors can invest freely in this technology area. Prohibited means that foreign investors cannot participate in these areas of technology. They cannot invest. Normally, these prohibited areas of technology are connected with sensible topics, for example, military technologies, and some health technology also are restricted. So I believe it doesn't affect to the vast majority of investors, because these are very limited. The significant part is that those areas that are restricted for foreign investment. In this case, it's not that your company will have to request for a permission. In this case, your company will have to adopt a very specific type of company when investing in this area of technology. The typical case is that only joint ventures with a Chinese party will be allowed to operate or to invest in this area. This means you will not be able to have a whole foreign-owned enterprise. The idea behind this rule is that these areas of technology are considered strategical, so foreign investor cannot own the entire technology. They will have to be co-owned with the Chinese party. What happens if we import a technology that is included in the negative list, and this is why you have to take into consideration this rule, is that your company will not be excluded for the ownership your company will not be excluded from an investor, but will be requested to adapt the company type to the rule that applies in this case. Most likely, it will be a joint venture. This means that if your company is settled a wholly foreign-owned enterprise, with this company that is actually a Chinese company, requests the permission for importing the technology, but this technology is in the negative list for foreign investment, then you will be requested to change the company type to joint venture and to find a Chinese party. So when we are talking about investing in China and transferring technology, we have to take into consideration all these catalogs that I mentioned. On the bright side, we have the encouraged industry catalogs. That is actually, again, a catalog of technologies, an area of investment that actually is encouraged to be transferred. And your company will have some benefits for doing it. By these benefits, mostly is about tax exceptions, but also you may be able to find some funds. Sorry. Regarding some tips about how to start thinking of how to transfer technology to China. The first tip would be, or my first advice would be, to study your business partner. But how to do this? Of course, there are different ways. One of them is by meetings and to see what's their purpose, what do they want with their technology, what's the final goal. But then I recommend you to visit the National Enterprise Credit Information Publicity System. That is a public database. It's owned by the Chinese government, and you will find all the information that is important about any single registered company in China. Here you will find some useful information. For example, who is the legal representative? This is important because only the legal representative is the person allowed to sign contracts for the company. So if you're performing or you're about to do business with the Chinese companies, please pay attention that the person signing the contract is a legal representative. You will also be able to find out what's the capital of the company, what's the business type or the business scope. This will give you a hint about if this company will be using or not subcontractors, because, for example, if your technology is in the area of, I don't know, mobile phones, but then the business type of the company you are negotiating with do not include as business type mobile phones, then most likely this company is actually having subcontractors or will delegate the business into a different company. You also will be able to see if this company was sanctioned in the past, so it gives you an idea of how reliable it is. And also who are the shareholders, who are the people behind the company. Finally, I also recommend to contact embassies and Chamber of Commerce and ask them who are these people, who is the people behind this company, who I am dealing with, and these institutions will be able to provide some information. Before I mention the importance of trade secrets, which I believe is the most sensible part of technology transfer, because all those IPRs that can be registered, if they are registered, then it shouldn't be any problem. Only pay attention to the catalogs, but then it shouldn't be any problem. The owner is the one that registered, is registered as the owner of the technology. But in this case, we cannot protect them. The only protection remains as long as the information remains as a secret. So when it is leaked, there's almost no protection at all. At the end of the day, we will be only capable of maybe requiring some compensation due to unfair competition, but that's it. So how to protect trade secrets? There are different methods that should be all used in combination. The protection should be as severe, as intense as the value of the technology. This means that if your technology doesn't worth too much money, then simple protection measures it's enough. But if you know that your technology worth a lot, is very significant, then you will have to use as much as protection as you can. And this is very important, not only because it seems logical, but when asking for a compensation for unfair competition, you will have to prove that the measures of protection that you arrange for your technology are coherent with the value, actual value of this technology. These protective measures can be physical. This means that you can just seal your document with the secret and confidential information. If you have a company charter, this means that you can restrict areas for certain specific employees. You can, for example, lock a prototype and make it unavailable for those employees that cannot will not be able to see it. You have technology measures, for example, the usage of blockchain and encrypted communication. Blockchain is very advisable because it will give you an idea of who had access to the technology and when. So it gives you an idea of who has been downloading for example, the documents or the photos of a prototype, and it's easier to track an employee because most of the time the leaks are coming from ex-employees or leaving employees or near to leave employees. Also, you have to take contractual measures. This means these famous NDAs or non-disclosure agreements, these confidentiality agreements that are very, very important, but we will talk about this in a little bit more in the future. You also have to train your personnel. This means that you can train your employees in order to, for reducing the chances of a leak. The idea is to give your employees those habits and include as a habit trade secret protection. Finally, you have court injunctions that are legal techniques in order to avoid leaks of information. There is a simple rule that I always recommend that is called the need to know rule. This means that sensible information should be only available and accessible for those employees that need to know this information, this technology, in order to perform their working duties. This means if the person, your employee, needs the knowledge to do his or her job, then that person should have access to the information or technology. If not, this person should be excluded from having access. And by access, I mean this is what I mentioned before, this area access, area restriction. For example, if you have a platform, online platform, then this person should not be able to download the document, etc. What are the company types that your company can, what are the company types of, what kind of companies you can have in China? You have the wholly foreign owned enterprise that actually it's the only method in which a foreign company can have full control of all the intellectual property rights in China. The advantage is that you will not need a second party. This means that your company itself can be 100% the owner of everything. And this means that you will have full control of the intellectual property right. The disadvantage is that it's restricted in certain technologies. Remember the catalogs that I mentioned before. And also a second disadvantage is that the new foreign investment law said that wholly foreign owned enterprises are forced to allocate 10% of the after-tax profits to make a fund for employee welfare. So actually there may be tax or profit restrictions that can be seen as disadvantages. You also have joint ventures, which are companies that are actually a combination of different companies that you have more than one member by definition. The advantage is that they are less restricted. This means that they can have access to the vast majority of technologies. They can invest freely or more freely than wholly foreign-owned enterprises. Also, if you want to have a Chinese counterparty, this is also the type of company that you will need. And it is always advisable to have a Chinese party because they bring you knowledge about the Chinese market and how everything works in the country. That is always, or most of the cases, beneficial for starting a new company. The disadvantages is that you will not have full control of the intellectual property rights, and also that the joint ventures agreements will have to be renegotiated every 5 years. So when starting one joint venture, you will know the terms and conditions, the rules for the next 5 years, but after that you will have to review it and renegotiate it. So that uncertainty can be seen as a disadvantage. Can I freely choose the company type? The principle is that yes, you can. However, again, because of the catalogs, you may be forced to change it into a joint venture. What are the principal clauses for a joint venture? First, you have to establish the nature of the relationship, what is the goal and the purpose of the joint venture. And if your company is looking for having some research and development, then this should be included in this clause. You will also have clauses for the company type. This means it is a joint venture. And also the share. I mean, who are the owners? Who are the shareholders? Who is the people behind the company? You also have a different clause for the parties' contributions. This means to establish what intellectual property rights or which capital it is added by each party. This is important from the point of view that the intellectual property right should be value, or the value of the intellectual property right should be fair in comparison with the capital, because sometimes people tend to value more the capital, the money, rather than the technology. But in many cases, the technology is a significant part of the business, not only the actual money contribution. Then you will have a different rule for how to share profits. But also you should take into account how to share the risk, liabilities, who will pay taxes, who will pay fees. Everything should be established in the joint venture before starting the company. Another important clause is the control, how to take control or how to make decisions. What is the decision-making process? Who will take the decisions when we have several owners, and how we can proceed if we disagree with the decision. In the case of research and development and technology, you also should include a clause about how to perform improvements. This is how to develop. If a new technology will be developed, who will be the owner? But also you should take into consideration that you have to set the rule about how to reward employees, because the Chinese law requires that those employees that participated in the improvement of the technology or directly the development of a technology, then they should be rewarded, and this reward should be reasonable. This means that should be connected with the profits that the technology will grant at the end of the day. And also take into consideration that if you have a Chinese counterparty in the joint venture and the improvements of the technology are performed purely by the Chinese party, the law will require you to give them a compensation for this job. This means that you cannot set a rule in which you and the Chinese party develop a technology, and then this technology, the owner of the technology, will be transferred to a wholly foreign-owned enterprise. This means that when planning to improve a technology, you have to decide in advance who will be the owner, and if your company's planning is settling a joint venture for actually then being considered the owner, sole owner of the technology, then you have to know that you will have to compensate fairly the Chinese party of this joint venture. Finally, let's talk about licenses. What are the main clauses in the license? First one is to decide the territory. When you license the technology, you can limit the territory in which it will be applied. This is easy to see in trademark, for example. The main idea here is to avoid parallel exports. This means that when you granted the technology or a trademark to a very specific distributor in a certain territory, to avoid this person to start exporting to third countries where you may have a separate and independent distributor with its own license. It could be the case that you limit the territory even within the country's territory. This means that you allow a person to perform businesses in a certain province, but not the entire country. You also have to establish what's the duration of the license, for how many years. This will be linked, of course, with the limits of the intellectual property rights with the registered intellectual property rights, because they don't last forever. You also will have to establish what's the content, what's the specific intellectual property rights that are going to be transferred. This is very easy with the registered IPRs because you should directly name what's the registration number. But in the case of trade secrets, it is very risky to establish or to mention them in the contract. So how can you protect your trade secrets, or how can you include them in the contract but not mention them? What you can do is to establish rules that will allow your company to determine in the future what will be considered a trade secret. For example, you can say that it's also all the documents that are sealed with the confidential seal, or any document that will be received or will be uploaded into a certain specific platform that has this and that protective measure will be considered as a trade secret, and then you connect this with the confidentiality clause, meaning that if any of these documents is leaked, then the company should pay compensation. Then you will be able to settle a rule for trade secrets without mentioning what are the specific trade secrets. Of course, and this is the most important clause for the owners of intellectual property rights, is what are going to be the royalties that will receive for transferring the technology. It is advisable also to set a rule that allows your company to control what is going to happen with the technology, this means that you may settle a rule for limit the quality and quantity of production that will allow you to visit, for example, the facilities of the other company to see what are the, for example, if the protective measures of a trade secret are being respected or not. You could also, at the end of the day, set a rule before selling or exporting some technology products that they will need your approval for example, quality. And this method of controls are very advisable, especially at the very beginning of the license contract. You will also have the chance to or should include a clause about damages in the case of an infringement to settle how much money should be paid. And this is particularly important to settle in advance the value of the technologies. This means that if this, for example, in the case of a trade secret, if a trade secret is lost, this trade secret for the company worth a specific amount of money. So if there is a leak, then you have this clause, then you will not have to discuss what's the value of the technology, because both companies already arranged that the value is that specific number. So again, the idea here is to, in advance, to protect yourself. Also, it is advisable to have a clause on conflict resolution methods. The most common ones are arbitration, mediation. Also, it's very important to determine the jurisdiction, because maybe you want a very specialized court to take your case, and then you can choose one of the intellectual property courts of China as the jurisdiction for your conflict. And in this case, you will have a very expert judge, more than capable of understanding and judging a complex case. Also, it's very important a clause for the return of documentation. This means that any document, any information that you provided with the license, to get it back after the license is finished. Finally, some other clauses that I consider that are very important is how to limit your counterparty. In the case of improvement, you cannot limit the other party to make improvement on the license, but what you can do is to set a rule in which if that other company improves the technology, that you will have a priority over any other potential buyer of the technology. You could also establish a rule for making an improvement and making cross licenses. This means that you license the base technology, and they license, if they develop it, they license you the improved version of it. You will also limit the possibility of providing sub-licenses, which is actually highly recommendable. And also you could negotiate if you license to a company your technology with exclusivity or not. You could set a rule about non-competence, that this company will not compete against you when using the technology. And also you should include a limitation on reverse engineering. This means that this company will not be able to perform, or shouldn't perform, reverse engineering. And if they do, that they will have to compensate you. And again, in this case, you will have to set in advance what's the compensation, what is the exact amount of money that they will have to pay if they infringe this clause. And finally, the most significant one, especially for trade secrets, is the confidentiality rule. In the case of China, The NDAs or non-disclosure agreements are considered insufficient, and NNN agreements are advisable. This means no use, no disclose, and no circumvent. No use means that that company will not use the technology to compete against you. No disclosure is actually the famous NDA agreement that it includes the prohibition of disclosing confidential information. And non-circumvention, this is not to overcome the rules and compete against you. It means not to bypass or to sell without your consent. Finally, some takeaway messages is to check the technology import and export catalogs, check the negative list for foreign investments, doing this in advance before start performing businesses, to study always your business partner and to protect your trade secrets. Also, when choosing the company type, please take into consideration the negative list for foreign investment, because you may be required after to change your company type, and if you chose wholly foreign-owned enterprise, you may be required to find a joint venture Chinese party with a certain limit of time for doing this. So you may not be in a very good position to license smartly to those companies that you already know and with the proper rules to protect the ownership of future improvements. And if you need help, to contact either your embassy or the China IPR SME help desk. Here on the screen you can see our email, and we normally reply within 3 working days, and we are free, fast, and confidential. So if there is any doubt or anything we can do for help, please contact us or visit one of our social medias. Let's go with the Q&A section.
Okay, thank you very much, Matthias. Thank you for such informative and practical advice. And now we have a few minutes, then we can go the Q&A section. If you have any question, either you can type in the chat box or you can raise your hand, ask by yourself. Okay, so let's see who has the question. Does anybody have any questions? Okay, maybe first of all, because really the technology transfer is really complicated. Maybe with so many information, maybe we can first of all just summarize what are the main aspects that a good technology transfer agreement must have. Maybe would you please give us a brief, summarized information about this?
Yes. What are the main aspects? I will say that first you have to analyze what is going to be the usage of the technology. This is going to be for business, for research and development. What is the purpose? With this in mind, you will know how to proceed. If you are talking about performing businesses, this means to manufacture products and start selling them, then you will have to pay more attention to the business scopes. This means that, for example, when licensing to a certain territory, how to control the production, how to control the quality, if that person will be able to sub-license or not, if that person will be able to export or not. This is, I think, the most significant part. When we are talking about research and development, I would advise you to pay attention to rules like the ownership, to rules of who will be the owner of the improvement, what kind of improvements, who will be able to register those future intellectual property rights, but particularly who will be able to register and where, because maybe your company, when your company arrange that the improvements will be registered in China under the name of both developers, but there is no rule about different territories. So this is very, very significant.
Yeah. Okay, thank you very much. Does anybody have any questions? Okay, now is about time. It doesn't matter, but if you have any IP related question, please feel free to send to us to our inquiry headline, question@china-iprhelpdesk.eu. This is our mailbox.
Yeah.
Thank you. Yeah.
Okay, I think we get another question. Can we please take
Yeah,
a
yeah.
look at it? Yeah.
Yeah. We just got the question. Yeah.
Yes.
I can read it.
Yeah.
It's,
So
it,
yeah, please.
Okay. Yes.
I see. Is there any format or for licensing technology transfer from your side which can send further for reference? I think this person is referring to a template for a technology transfer. Normally, we advise to actually have a tailor-made contract, but I think we have. I can look for one that it could be used as a template, but again, I advise you to review it with the technology transfer lawyer that you may have or your legal department, because they have to be tailor-made. Otherwise, you can have an unpleasant surprise.
Okay.
Yeah.
I mean, please, if you can send me an email on this on the email that you can see on the slide, and I will be more than happy to reply to you.
Yeah, well, thank you for giving us such a nice presentation. It's just so difficult to summarize such a difficult topic into such a short time. But anyway, Switchem will just post our materials on our website, and through our website, our attendees can also get the information of your email address, etc. So thank you, everyone. Like, it's really nice to have you here, and have a good night or a good day. Thank you.
Thank you. Bye-bye, everyone.
Bye.
Bye. Have a nice day.